Hello, everybody. Thank you for coming to this Wilberforce Chambers online seminar about demystifying the Chancery Bar and the commercial Chancery Bar in particular. I am Jonathan Chu. I was called in 2010, so I've had about 10 years of practice here at Wilberforce. I do principally property and pensions work, and we'll come on to talk about that a little bit. I am a member of our pupillage committee, so later on we'll be talking about some of those aspects as well. I'm also joined by Jenny Seaman, who was called in 2007, so more experienced than I am. We are thrilled to have her in Chambers because she's joined recently and she's brilliant at her private client and pensions work. And you should be thrilled to have her too as well because of her experience in other sets. So that means we can give you a bit of a broad width today. And we also have Joe A. Lee, who is 2017 call. He's got a broad Chambers practice doing quite a lot of fraud at the moment, he was telling me. He is also a double benefit to you guys because he is both a recent pupil, relatively recent pupil, and also a member of the pupillage committee as well. So we wanted to, and I hope we've got as wide a range of barristers as possible for you today. There is a Q&A function, and I can see one person's already used it, which is excellent stuff. If you could use the Q&A functions to stick any questions you have in, we will pick them up. Those questions can either be named or anonymous. I'm certainly not proposing to read anybody's named out. As far as we're concerned today, there's no such thing as a stupid question, and this is your opportunity to get the information that would be useful for you from us. So if you have questions, do please put them in there, and we will probably pick them up at the end rather than as we go. But we would like to provide as much use as we can. So we will pick up those questions as we go. That is probably enough from me by way of introduction. The first topic that I'm going to ask Jenny to take the lead on is what exactly Chancery work is. So over to you, Jenny.
Thanks, Jonathan. So in essence, Chancery work is civil work, so as opposed to criminal litigation, and it involves often a strong international element, and many claims that you get involved with are quite substantial and complex. So it involves a careful thought and approach to the case, and it is mainly for people that like an intellectual challenge. But Chancery work is extremely varied and interesting. It's not all about contracts and arbitrations. It also varies in value substantially. So you have an opportunity when you first start to work on a relatively small, low value case, but it involves nonetheless extremely important legal issues and complex topics that you have to think through. So from my perspective, I think Chancery work involves 6 main different areas of law that Chambers covers. I'm going to run through those 6 areas. The first is company law, also insolvency and bankruptcy. So for example, Chambers has been involved in the Nortel litigation that went right up to the Supreme Court, which restated the law on what debts are provable in an insolvency situation. And we've won the Insolvency and Restructuring Chambers of the Year 3 times. The second area of Chancery law is partnership disputes. And partnerships can range from partnerships based on a contract, LLPs, corporate partnerships and trusts. And you can be asked to advise partners on disputes relating to partnership assets, for example. So if they're investing in property and developments and how those disputes get resolved. The third main area of Chancery work is property. And Chambers advises in all aspects of land law, including the upcoming Court of Appeal case called London Trocadero and Picture House Cinemas, which is whether the tenants of a commercial property are liable to pay rent for the periods that the property was closed because of COVID. We're also involved in art and cultural property cases. And I know that Jonathan's had a recent experience in a pretty cool case in that area. I don't know if you want to mention that here, Jonathan.
As you so kindly set me up Yeah, you go on then. I don't do a lot of art or cultural property law, but what I did do recently was a dispute about who owns a Damien Hirst, and I was acting for one party who it turned out at trial he did own it, but basically he'd been collecting Damien Hirst and quite a lot of these other young British artists, or Tracy Emin and people like that, from the time of their degree shows, and then 20 years later there'd been a family falling out, and an offshore company that was controlled by other members of the family said, oh no, actually we paid for that, we own it. And so I think, Jenny, coming back to what you were saying, that's quite a good example of how the chancery work can mix across a wide range of different areas, because this was ostensibly a title dispute, but actually there was an offshore company involved. Who was behind that offshore company? Actually, it was private individuals. So you had a family dispute masquerading as an offshore commercial dispute, masquerading about actually who owned title. So that was my Damien Hirst. Property, the other point I'd just chip in on, is the breadth of the work you get and the different sizes of it is brilliant, because on the one hand here we've got some of the leading QCs, and I've done some fantastic work as a junior on massive developments and buildings, you know, Canary Wharf, Grosvenor Square, proper like A-list glam disputes. And then I've done some real like little small tiny disputes about tiny properties in East London, or you know, caravans in Cornwall and things like that, and it can properly get you into court early. And as with quite a lot of chancery areas, the principles can be really difficult on a small claim just as much as on a big claim. I suspect that's probably true about trusts as well, but I don't do that much of that, so I'm not going to guess anymore.
Well, that leads me on to the last three topics that I think are involved in chancery work, and that's the three areas that I tend to practice in, which is trusts, pensions, and contentious probate and estate matters. So we're the leading chambers in trusts law, and we're often involved in the leading cases in this area. And trust disputes range in variety completely, from low value, small family trust issues to extremely high value offshore trust work. The kind of issues that you get involved in trust law are the nature and scope of trustees' powers and duties, the interpretation of trust documents. It can involve tax planning, and you're often asked to advise in relation to trusts involved in a commercial type context, where businesses use offshore trust structures to more efficiently manage their assets. You can also be asked to advise on matrimonial proceedings, so where families who are divorcing have got assets based in a trust structure. There you could be asked to give specialist advice. So moving on to pensions. Now, again, Chambers is recognised as the leading chambers in pensions law, and members of Chambers have appeared in almost all of the leading pensions cases. I didn't go into my practice thinking, right, I'm going to be a specialist in pensions law. It kind of just developed gradually and organically as you work with leaders and they get you involved in certain cases, and then you develop experience and a specialism in that area, and more cases come in that type. So what do we do in pensions cases? So we're often asked to advise, it's essentially trust cases, but with extra pension legislation, bells and whistles added on. We're often asked to advise trustees, members and employers on pension scheme issues such as, do I have to pay this amount to members of a pension scheme, or am I entitled to this amount of a pension? Has the pension scheme been amended correctly? Have the right deeds been signed? Have the trustees considered all the appropriate issues they need to consider to administer the pension scheme? And we've appeared in cases at all levels. So when you start off, you might be involved in an ombudsman case in your own right, or it can go all the way up to the Supreme Court, where you're working in a large team with a couple of silks. And the last area that I want to talk about that I think chancery work involves is contentious and non-contentious probate and estate work. Again, we're the leading chambers in this area, and we've won the Chambers High Net Worth Set of the Year recently. And cases in this area can include issues such as whether or not a will is valid, how a will should be interpreted, whether the will should be rectified if it doesn't meet with what the parties wanted it to say, and issues arising in the administration of an estate when someone passes away. And members and chambers were involved in the relatively recent Lucian Freud case, where there was an issue as to whether or not Lucian Freud created a secret trust. And we're also involved in the Supreme Court case of Marley and Rawlings, which is a case involving a man and a wife. They mistakenly executed each other's wills, and it was how that was to be unravelled, involved issues of rectification and construction. So you've also got professional liability issues stemming from these 6 main areas. So we can often be asked to be advising someone that wants to bring a claim against a negligent professional or defending a negligent professional in relation to any of those main areas. And certainly from my perspective, people tend to specialise in more than one area. So you've got a really varied practice. I know Jay, he does fraud and commercial, as well as feeding into those areas some of the chancery issues that we've spoken about. Joey, I don't know if you want to talk about how wide your practice is.
I mean, one of the things that drew me to Chambers in the first place was that I can really decide what kind of law I particularly enjoyed. Sort of anything vaguely private, I like, thinking and writing about. And it's quite a nice thing then that most of the quote commercial cases that I do aren't strictly just commercial. So there could be a banking dispute where Bank A says that its client was moving assets out of the country to frustrate a guarantee. So it looks like a contract claim, but actually then you think about enforcement, and the money's moved around all sorts of different jurisdictions. So there's a conflicts angle. But not only has it moved around jurisdictions, but you're trying to enforce, the company that you're trying to enforce against might be insolvent. So there's a company law insolvency angle that's drawn in as well. And then you have all sorts of unfair prejudice petitions, preference payments, that kind of thing. Fraud often involves asset tracing. So you want to establish a claim over a bank account that's overseas, for example, or you've got a property in a jurisdiction that's much easier to enforce against. So how do you get there? You have to bring a trust claim of some sort, establish a proprietary right in that. Or it can be a fraud about a piece of property. And then not only do you have the fraud elements like dishonesty and so on, you have to value the property. There might be complex questions about what encumbrances attached to that property, that sort of thing. Even pensions, pensions, liberation, scams, that sort of thing, or were at some point a quite fruitful area for litigation. So if someone says that they're a fraud lawyer in Chambers, that could mean that they do a huge range of different things at once, because basically you can lie about anything, so you can have a fraud about any kind of law.
I think that's true, isn't it? That's a really good example of quite a lot of areas of Chambers work, because I think one of the differences between practice and studying for practice is real life problems don't just fall into one category. Most of the time, you listed out there, Joe, about the 5 different practice areas that a fraud claim could cover. But even just a simple property claim where you think, oh, this is a real property claim, well, hang on, there's misrepresentation here, we've got rectification, there might be an overriding trust claim or a separate overriding interest property claim. And I think I was the same. One of the things I liked about the breadth of Chambers was that opportunity to work out what you like in and then specialise a bit, but also knowing that you're not just looking at in this one narrow box, because life doesn't come in narrow boxes.
Yeah. No, thanks, guys. I also want to highlight that as well as the variety that you get in the different legal areas that you may be asked to cover, it's not just contentious work. So my practice often involves a lot of advisory work before things get contested, so where you're being asked to advise on transactions, drafting trusts, other structures involved in a deal, and give opinions on complex legal issues that might arise in any of these different areas of chancery law that I've spoken about. So there's a strong element of my practice that is paper-based, which I find as a parent of young kids that means that I can manage my time really well, and I can spend lots of time with my children, as well as having a really stimulating and enjoyable job. So I think we were going to talk more now about what life as a Chancery barrister actually involves.
Yes, I was just going to pick up on that, actually, because I think, well, I was going to make two distinctions about the type of work and then maybe broaden it out to just talk about life at the bar a little bit more generally. Now, with the enormous lawyer's caveat that anything I say here can only be a massive generalisation, and there are as many practices as there are barristers at the bar, and everybody does it their own different way, which is one of the advantages of the job, of course, that you can do it yourself. But turning to my first distinction, which is between court work and non-court work, in terms of how often you are in court, for myself, I would say on average, I'd be in court 1 day a week, but that varies from month to month and from year to year. So for instance, I can have months where I'm in court once or twice a week on a series of small hearings or small disputes, and then you've got nothing for a month or maybe 2 months because you're preparing for a 3 or 4 week trial. So it's not just about, oh, what am I doing this week? It really is a case of you have to look at your practice in 6 months or year-long blocks. And so court work itself makes up a reasonably small part of practice if you define court work as being simply the time you spend physically or virtually in the courtroom. Most civil cases, even when they get as far as a barrister, and quite a lot don't, settle. So that means that trials, hearings that go to a final decision, are, unless you're a specialist silk with 30 years court who just does the big trials, they make up a small part of your practice. But there are many other types of hearings that we do. So parties might take a preliminary point that there's no defence, or the claim should succeed, or the claim is hopeless, and you argue about that. There are procedural hearings about setting a timetable. There are particular specialist hearings in areas like trusts or insolvency that work in a slightly different way because the court has a supervisory jurisdiction. There are hearings where you go and have to seek court approval for certain matters. Even after a trial, for instance, you can have appeals where you don't hear the live evidence, and as Jenny was saying, you can go all the way up to the Court of Appeal and then on to the Supreme Court. So that there are a wide range of individual types of hearing, as well as just simply the set piece trial. And of course, going back to what I was saying about the time in court being a reasonably or not that large a proportion, you don't just rock up and do a court hearing, really. A written argument called the skeleton argument goes in beforehand. That quite often has to be in a few working days beforehand, so you're already starting to prepare for your court hearing substantially in advance. And if you're being led, if you're working with a QC on a large case, you can find yourself drafting a written argument. Let's say you've got a 1-day hearing 2 weeks from now. Well, I have to start my writing on that around now, so there's time for it to go to the QC to check they're happy with it and they have their input, and then we discuss it amongst the counsel team. It then needs to go to the solicitors so they can look at it, and it goes from the solicitors to the client, and then it comes all the way back for me to do the tidying up. So, that might be the 1 day a week in court 2 weeks hence, but actually it forms part of my life for a much stronger and a much longer part of that hearing. In terms of out of court work, the paper-based practice, Jennifer's talked about opinions and drafting issues and things like that. And they are sort of set pieces that arise on particular matters as and when they happen. There are also either written work or telephone calls or Zoom calls or whatever on ongoing cases where actually you find yourself spending quite a lot of your time, especially I think as a junior, engaging with particularly the senior associate who's running it just on sort of ongoing case management. You're reviewing documents as they arrive, you're reviewing or drafting correspondence for them, you're working out what evidence is needed, what witnesses do we need, where are the gaps, what are the problems. And I think barristers are much more, especially in Chancery commercial work, I think, are much more integrated into the litigation team than they used to be. We do provide ongoing assistance to the solicitors on matters of court practice and matters of technical evidence. It's not like what you see on TV shows or in crime, where you just, here you are, there's a brief, go and do that hearing at 10 o'clock the next day. Actually, you're always at the end of the phone or the end of an email, and you can be working on cases for up to 18 months before they get to trial. Which brings me actually to the distinction between larger versus smaller cases, or led and unled cases. Some cases arrive and disappear as one-offs. You do this opinion or that hearing, and you never even hear about it again. I mean, quite often, I don't know what you think, maybe this says more about me, but quite often somebody will come to you for an opinion or a piece of drafting, you do it, it goes away, you never hear from the solicitor again. You've got no idea whether the claim was ever issued, if they settled it successfully, you just don't know. And then large cases, they can run for years. Got QC Junior, like Jenny was saying, 2 silks or whatever. If you've got experts involved, you could have 2 or 3 experts. All of a sudden, you can have a team of 7 or 8 people, plus a couple of client contacts on litigation. And I think one of the things someone taught me relatively early on, that for businesses, litigation is a project for them where they are trying to get a financial return out of it, either minimizing a liability that would otherwise affect the business, or recover money that they think they're owing. And so actually there's a reasonable amount of project management and working out how to get the return on the legal spend. Because if you've got a company that's going to be spending £250,000 on litigation, they need to be able to show to the board and to their shareholders what they're going to get in return for that investment. And if you've got a £5 million claim, say, you need to work out, well, how likely are we to win it? How much money is it worth spending on these points? And I think, again, that project aspect of it is something that, when you're studying law, that's not how you think of it, but we are there as a service to help these businesses achieve their aim.
There's a point made in the chat box rather than Q&A box about the importance of commercial awareness and knowing how businesses work. I mean, we'll leave the question about whether it's asked about in interviews for later when we talk about pupillage, but just the point that Jonathan's making is, I think, answers that in part, in that we do need to have an understanding of how our clients work and what their commercial objectives are. It's not as if we need to have specialist knowledge. If your client's a mining company, you won't be expected to know before you come into the job how mines operate. I mean, I actually did a mining case and I still have no idea how mines operate. But you do need to have a grasp and an intuition, at least, for what matters to business people, what matters to commercial actors, and different kinds of commercial actors. The director of a small company will have a wholly different view of how things work than a general counsel at a multinational. So commercial awareness does matter in our line of work. We're no longer just coming in, advising on a discrete point of law and then leaving. That sometimes does happen, but most of the time we're involved as part of the full team. And that just is not just solicitors and other counsel, it's also the clients themselves.
Yeah, I think when I was studying law at university, I'd sometimes think, well, why didn't they take that point on appeal? Why was the case presented in that way? But it's often the commercial reality behind the litigation that governs why certain points get put.
And you get, this happened to me very early on. I'd have somebody come to me who was like, they've been a solicitor for 25 years, and they instruct you and they say, oh, well, we just wanted your tactical view on what to do next. Then, I've not got a clue. I've been doing this for about 2 minutes. So it's not, commercial awareness it's sort of quite a hackneyed phrase, but I think the awareness aspect of it is quite important, because it's slightly different to commercial knowledge. It's not, as you were saying, it's not about knowing how a particular business works all the time. There will be cases where you need to get under the hood of a business and understand how it works, but you need to be aware of the reality in which your clients and their competitors are operating. I don't know about how we do the type of work. I was going to say a bit about that. I don't know if either Jenny or Joe, where you had anything more to add on that, to what we said about commercial awareness. Or
No, I suppose some of the cases that I'm involved in, so probate especially, and sometimes trusts, that you don't have necessarily a client with commercial awareness. It's all about the principal and how much they hate their family. So you have to have the soft skills in those cases to try and possibly reach a mediation, or try and limit the number of points that they want to bring. So there's other angles to chancery work. It's not just a pure commercial focus.
That's a good point. That's also a good segue into another comment in the chat box. I'm turning into a DJ here, but somebody's asked, do we do arbitration, and what are our views on mediation? How is it regarded? Arbitration, particularly in the more commercial end, we do quite a lot of, because it has the advantage of being internationally enforced more easily, and also commercially secret. So it has advantages for clients in that end. Certainly a lot of sort of infrastructure projects, or oil and gas type disputes or frauds, that kind of thing, that there is arbitration. For my part, I treat it as not dissimilar to litigation. The process is different, but it is still a binding dispute resolution process that starts with formal documents, and then you have argument and evidence. Mediation, it is slightly different, because you can mediate at any time in a dispute, and it sort of sits alongside whatever process is existing and going on. Generally, I think mediations are a good thing, because I suppose, going back to what I was saying earlier about net spend and getting the result, quite often a good settlement, or even a settlement that all parties are a bit disgruntled with, will lead to a better net result than everybody fighting at trial, and you buy off the risk of losing.
Yeah.
I don't know, do you want to go talk about mediation? Yeah,
you to some extent, especially in the private client cases, you have to be shown to mediate, so the courts expect that. So everyone has to go through the process, and I think often it's extremely successful.
I don't know if there are any qualified mediators in Chambers. I can't call. I'm sure it's on the website somewhere. I should know, but
we've got at least a couple, I'm sure.
But in terms of our involvement, even if we're not mediators, barristers will be involved in the mediation itself. We are often asked to show up to either advise the client about whether to accept or not accept offers. We are asked to help with position statements for the mediator, that kind of thing. So whenever there is a mediation in the course of a dispute on which we're involved, as counsel, we are often involved in that mediation as well, to varying degrees.
Yeah, just in answer to your question, Joey, I've just had a look on the website. We've got 11 mediators in Chambers.
There we go.
So, yeah.
You'll be in trouble later for that. The other point I wanted to just talk about more generally before opening on to sort of handing over to Joey really for early practice, is just the working style of the civil bar as a whole, and actually the commercial chancery bar doing what we do. And it's probably obvious, most of you on the Zoom probably know it, but we are individual self-employed practitioners. So each of us are essentially our own small business that operate under the common branding, and we pull together for the common support services that Chambers offers. Now, as far as I'm concerned, it's absolutely the best thing about the job. I am getting less and less employable the more I go on, and the idea of just going into an office where I had to report to a line manager or do things like that, I would just be completely useless at it now, because I have been doing it my own self-employed way for getting on for a decade, which is terrifying, but there we are. The flip side of that is it's not for everybody. You need to be comfortable making decisions, taking responsibility, organizing your time, learning when to say yes or no to stuff. The sort of the comment I made earlier about someone coming to me who was much older than I was, saying, well, we want your view on things. Now, if that view is we want your legal view, go away and do some research, even at the very start of your career, that's okay, because you think, right, well, I'm pretty good at law, I know what I'm doing, I've been taken on, I can go away and research it. But if somebody says, oh, I just want your tactical view on something, it takes a while to build up that experience. So you have to back yourself and have, you know, enough commercial awareness or whatever label you put on it, but you have to back yourself to be able to give useful advice to the client, knowing what you know about the court system, even if at the start it's not massive. But that the flexibility to work to a degree when it suits you, you know, are you an early morning person? Are you a late night person? Would you rather knock off earlier and do some work at the weekend? Or would you rather keep your weekends free if that means working a bit later? There's a lot more flexibility to that there's not really a FaceTime culture because you're your own boss, so you don't have to be there. The flip side is if something needs doing, there's no one else there to do it. So it lands back on you. You know, holidays, you can choose how and when to have them. You don't need to put in to get your days approved or anything like that. But court hearings, big trials can be arranged 12 or 18 months in advance. I mean, a few pre-COVID, obviously. I had an amazing holiday in South America that this job paid for, but I had to postpone that for a year because of how work felt. So we didn't get it in. And that's, you know, you pays your money and you takes your choice in terms of the job. Again, do you want to work from home or do you want to work from Chambers? Chambers has a great location, it's a good atmosphere, but it's up to you. Is it easier for you to go in and work there, or would you rather work remotely? So I just think the flexibility is key. And the flip side that comes with it is the responsibility. And that might be a good point to hand over to you, Joe. I don't know about how that feeds into early practice.
I was just,
sorry.
I was just going to say a couple of points. So after I had my first daughter, because I was self-employed, I was able to decide, right, I'm going to do 4 days a week because that works for me, and it means I get to spend more time with my daughter. And because you're self-employed, you can choose to do that. I can choose to take them to school. I can book out my diary that I need to attend sports day or whatever it is, and no one's going to you know, accuse me of not putting in the right FaceTime. As long as I get my work done at the end of the day, it's brilliant, you know, having that ability to be flexible with being self-employed.
I was just going to pick up actually on the Q. We've got a Q&A that says, as a self-employed practitioner, how often do you source your own work? And that varies. I think at the very start, nobody really knows who you are, so most of your work comes in with Chambers' name on it, and they just want someone more junior. But then as Jenny was saying earlier, as you build your practice and get known in a particular area, people come to you because they know you do some work. They may have worked with you before. Best of all is if they've been against you and then they choose to turn around and instruct you, then you know you're doing something really right. And the clerks and the Chambers reputation do an awful lot to get the work in, but maintaining your own practice and your own visibility in terms of spending a bit of time on marketing and talks and seeing people forms part of practice just as much as doing actual paying work.
Yeah. Just on that, so I've had experience at 2 other chambers before I moved to Wilberforce 4 months ago. And I can say that the clerking team, so the people that bring in the work and get your name out there and try and promote and build your practice are excellent, as well as the marketing team in Chambers. They're great at helping you come up with ideas for talks that will get you and your name out there to the solicitors that you want to be seen in front of. So yeah, big thumbs up.
Which is actually a nice segue, that's the word again, to talking about early life at the bar. I was actually proposing to just quickly talk about the transition actually from pupillage to becoming a tenant. I mean, as a pupil, life is actually quite structured. You know, someone assigns you your work. Someone says you got to finish XYZ by XYZ date. Your working hours will be quite constrained. It will be in Chambers anyway. It show up around 8 or 9 o'clock. You're done by 6 o'clock. You won't be expected to work weekends, that kind of thing. But the moment I started as a tenant, certainly that went out the window. You know, no one was going to say, "Oh, here's your assigned work for the week" or whatever. No one was going to say to me, "You've got to finish this by whatever date," apart from whatever court-imposed deadline there was, which was liberating in one sense, but also anxiety-inducing, because at the beginning of my career, there was no work because nobody knew who I was. Whereas my co-pupil, actually, because she was involved in a long-running case with her pupil supervisor at the time, just got dumped onto that case, and so I had a steady stream of work from the outset, which is even more anxiety-inducing. I was like, "Well, am I doing something wrong? Why am I not being paid anything?" it proved, a bit of a flash in the pan, because really the work did come, and the clerks were quite good about holding my hand through and saying, well, don't worry about it. It will come. We're putting your name out there. When an opportunity that is right for you comes, we'll put you forward for it. You'll probably will get it. And that's one of the assurances of being at chambers like Wilberforce, in that in the end, we do know that there is sufficient demand for barristers from chambers, that the work does eventually come if we're willing to take it. And there are all sorts of other policies in place, like a bridging loan that chambers gives to first-year tenants to ensure life is a bit easier at the start. And we don't pay any room rents in the first year. We don't pay chambers contributions from our income in the first year. So that eases a bit of the financial anxiety and pressure, because income's not forthcoming early on anyway in the career, until a little while when you've done some work and the clients start to pay. So there was that. It was that transition from structure to no structure and no certainty of work coming in, at least for a while, which also meant me needing to learn a second lesson, because once the work did start coming in, my thinking was always, oh, hang on, it'll stop at some point, so I just need to say yes to every single thing that comes my way. And then at some point, halfway through my first year, I was like, oh, hang on, this is not manageable. I can't, there's too much. And I was working quite slowly, because obviously I was new, wasn't super confident, so I was being doubly careful with every single thing that I did. And that was when I had to learn the second lesson, which is, in addition to managing anxieties about what work would or would not come, it was learning how to establish my own boundaries and having the discipline to say, okay, this is enough. This is as far as I can go without compromising my own, not just the quality of my work, but also my own quality of my life. And that's important. Depending on it, again, it varies from person to person. Some people are content, working 16, 17 hours a day. If you're not that sort of person, which is, again, perfectly fine, and in fact recommended that you don't become that sort of person, then you need to be disciplined about saying, okay, today I will work from X to X hours, and I will try my best not to exceed those. I will try to make sure I have a weekend to spend with my family. And if I need to eat into that, then I'll budget a holiday further down the line or whatever. It's up to you how you balance it. But, that discipline of learning to draw boundaries and lines, that's something that I think self-employed practitioners in particular have to figure out for themselves, because there's no structure around us to tell us what to do anymore. So that's really about early life at the bar.
Can I just chip in on that? Because I think that that is an almost universal experience, by which I mean I've had it as well, and I know from other people. Because you get that thing where, and I think it takes a few years for it to build up. You might have got there a bit quicker, but I found it took a few years to build up, and all of a sudden you found yourself going, oh my God, I just can't keep going at this rate. And because maybe things take a bit of time to get going, or because you're only doing work because they come in through the chambers door and you want to build your own name, and we're all reasonably competitive people to sort of work in this area, you think, right, yeah, I want to do it. And it takes a while for you to learn to step back. And at the same time, the work you're doing is getting more complex because you get more senior. So you sort of have this double ratcheting effect where you're too terrified to say no to stuff. And the stuff you're doing is often getting more complex, certainly to a degree that exceeds the time you save by getting a bit better at it. So all of a sudden you think, oh, well, I used to be able to do a pleading in half a day, I can squeeze that in. And then you go, oh, blimey, this is something really quite difficult that stepped up a level. This will take me a day and a half. And then all of a sudden, that's your third weekend in a row gone. And you think, hang on, I just need to recalibrate a little bit. And I found, I don't know, Jennifer, you're more senior than me, but I sort of found your career kind of a little bit going sort of stages like that, where all of a sudden every few years you find yourself hitting a point where you're like, oh, I feel like I've stepped up a little bit. And you just need to sort of do a sense check to see how it's going at that point.
Yeah. If I look back at how I worked when I first started, because everything was new and I was terrified of being in court. Yeah, I used to work crazy hours, but since having kids, and it's forced me to just say, look, no, I can only fit in the kind of work that I can fit in, and the clerks are great at helping you achieve that, and be strict with your time. So it's just, I think it's about learning that discipline, especially when you're self-employed.
Yeah, I mean, I'd heard all these horror stories before starting as a tenant that clerks will, control your life. There's all these. There was an MSNBC article, I think, written by American of all things, about the weird culture at the bar and how clerks control your destiny and how they'll force you to do things you don't want to. I've not found any of that really.
Did they make you say that?
Yeah. maybe. I'll reserve comment on that. No, it's true. I mean, the clerking team is genuinely there to help you achieve whatever career goals you decide to set. So if you decide that this is on a certain kind of practice that may not involve, working too much or working too little, whatever, they're there to support those goals. And I think that's the sort of third thing that I picked up as an early starter in Chambers, which is it's actually quite odd, this career, because there's no sense of progression. It's not like in a law firm or any other job where you can get promoted. The only real promotion that's available is when you take silk, or if you take silk. That's the only obvious change in status, and even then it's just a thing in the back of your name. So how does one then track your development and growth beyond maybe your income increasing year on year? Chambers does have fairly regular personal development meetings with everybody. And I think that's quite useful because it forces you to sit down at some point and step back and say, well, what am I actually doing here? What specialisms, as it were, have I inadvertently developed? Is this the direction I want my career to be moving in? Have I built the kinds of client networks that I want? Is this the income target I want to be meeting in this year? So on and so forth. And that, stands as a quite nice way of stepping back and saying, where am I? Because otherwise, the other proxy is to start comparing without real information with your colleagues. Someone's in a really exciting trial for 3 weeks or whatever, and you think, oh, I'm not doing that this year. What's happening to my practice? When actually there's a lot of stuff going on in the background and behind the scenes you don't know about. It's not really possible to compare careers between barristers. So having objective, if you will, close to objective ways of standing back and assessing your own development, I think is an extremely important thing that I had to figure out for myself. Because at some point I could start to feel the jealousy creeping in when my colleagues from ±1 year were taking on all these big cases and I was still doing possession hearings. But then there was a trade-off. They weren't getting into court very much at all, whereas I was getting a ton of court experience at the outset. And eventually it all leveled out at some point. But comparing wasn't a good way of trying to figure out where my career was going. And that was the third thing about early life at the bar that I was picking up. And the fourth thing about Chambers specifically is that actually it is, we say this almost as marketing guff sometimes, but it's true in Chambers' case, that it is actually a really supportive environment. Before COVID struck and everybody was in all the time, doors were really genuinely open. So when we say open door, we actually mean a physically open door. You could, there's one building in Chambers where the doors don't shut, but don't stay open, sorry. But apart from that, people were genuinely willing to entertain conversations or questions from junior members anytime, even as a pupil. I found that really helpful because it was silly questions like, do I have to robe up for this hearing? I had no idea, and I'd just pop next door, ask somebody, and they'd help me out. And that was very helpful because starting out in any job, really, especially a job where there's don't appear to be any guardrails like this one, can be quite difficult and terrifying sometimes. And it was nice to have people around who've done that and said, well, we're here for you, don't worry about it, you'll be fine. So that's really what I have to say about my early days at the bar.
And actually, you can see, just picking up on that last point, you can see that everybody has done it because, you see people who, +1, +2 years ahead of you, and you're like, absolutely. Oh, no, it is fine. Which I remember finding quite reassuring.
Yeah.
Still do, to be honest.
We want to talk about pupillage quickly. I know we're pushing time.
Let's do that. And then, we've got quite a few questions on pupillage and that kind of thing that we could probably pick up as well.
Yeah, and we can pick some of these up while talking about pupillage, actually. So we offer up to 3 pupillages per year now. So that doesn't mean that every year we'll have 3. It's sort of between 2 to 3 pupils we take on per year. Pupillage is non-competitive, and I think that's a very big point we want to emphasize to anyone who wants to apply here. We take on our pupils with a view to taking all 3 of them on as tenants, so long as they meet the required standard of ability. And that has the effect of meaning that pupils can mutually support each other. They're not afraid that if one does well, the other will lose out. And that reduces a lot of the unnecessary pressure in a year that we know can be quite inherently stressful. When we're looking at candidates for pupillage and indeed for tenancy, we want to look at the three main qualities. Intellectual ability, that's really important. So that's how well you can think and how well you can think like a lawyer. Number two, oral advocacy ability and written advocacy ability for that matter, how well you can persuade somebody in writing or in speech. And lastly, whether or not you've got the required interest in pursuing a career at the Chancery Bar. And that's things like, broadly speaking, whether or not you're interested in the subject matter, whether you've demonstrated a mature grasp of an understanding, at least an early stage, of what the type of work we do is and so on. So those are the three qualities. In response to the question in the chat box about whether you'll be asked about commercial awareness in interviews, well, I mean, we can't tell you in advance what the interview questions will be, so I'm not going to say too much about that, save that obviously no one's going to ask you, do you know how a commercial trust company is supposed to work? Do you know how a pension administrator operates? That sort of thing. If it's commercial awareness in the sense of commercial knowledge, we're not going to test you, as it were, on what's happened in the FT or the Business Times and that sort of thing. The interviews are primarily problem questions, and the aim is to figure out how well you think like a lawyer. So it's not even about legal knowledge as such. You'll need to have a good grasp of the basics of law. You'll need to know how contracts work, how trusts work, understand how the pieces fit together. But if you don't know the ins and outs of the latest Supreme Court decision on, illegality or whatever it is, that's not going to be a problem. It's not about knowledge. It's about your thought process and how agile you are under the pressures of an interview environment.
And I think part of that thought process as a lawyer, as well as an applicant, ought to lead you to cross-check to the commercial outcomes of what you're saying. So I mean, not going into any specialist interview questions, but I suspect this will be true of any commercial set to which you applied, or any chancery set. If your reasoning leads you to a result that has a commercially absurd result, I would expect that to be pointed out to you in interview, and you'd be sort of challenged on it, and your ability to take on that new information or defend your position would form part of that interview process.
Yeah, absolutely.
Jerry, I just wondered if now's a good chance to deal with Lucas's question in the Q&A box. He's thinking about what topics to study on the BCL, which is like the master's degree that you can do at Oxford. He was tempted by advanced property and trusts, but also wanted to have exposure to an area he hadn't studied before, such as IPL. What's your thoughts from a kind of pupillage perspective?
So, broadly speaking, I think we can answer anonymous attendees' question at the same time about how valuable the BCL is to an application, and broadly speaking, how valuable a first is to an application. The answer is that having a first-class degree, or strong grades, or a master's degree from a very reputable course like the BCL can only help your application, but it's not a necessary feature of the application. I mean, if you just scroll through the CVs of the past couple of candidates, there's a mix. Obviously, some have done the BCL or a master's or an LLM somewhere. Several have not. Many are on the GDL. So it's not a necessary condition, but it is helpful. One is looking at your intellectual ability, and the more pieces of evidence you have of that intellectual ability, the better. Specifically dealing with the choice of modules. Again, this is, I can't give black or white. Oh, this, if you do APT, you're definitely going to get in. If you don't, you're not. It helps evidence interest in the subject. It helps to evidence, if you do really well on APT, for example, that you've got aptitude for the type of work that Chambers does. But at the same time, if you're interested in international public law as well, then, and you've got good grades on your trust course, we're not going to mark you down for having done something else on the BCL that you're interested in. Good lawyers are not confined to individual topic boxes. So the broad advice, life advice maybe I would give one is, do the things that you are in fact interested in when you're pursuing your master's degrees. A, because it probably means you'll do well on it if you enjoy it. But B, because it's not a necessary condition to have done certain subjects or done certain master's degrees to get pupillage here. the key is, what evidence do you have of intellectual ability? BCL, advanced property trusts, that sort of thing, electives in the relevant topics, those help. But there are other ways to get there too. So do what you're interested in. And obviously, if you have no interest in trust law at all, or property law, then one must also reconsider and reevaluate whether you really want to be.
I mean, I think that's it. I think you need to be aware of why you're doing it, and you by the time an interview comes around, you need to have a narrative as to why you've done what you've wanted to do. And your interviewers are humans, and they want you to succeed because they've spent quite a lot of time with you and going through the application. But if you've not done a very specialist course that's specific to a particular set of chambers that you're applying to, you need to be aware of it and have an answer. I mean, because I did the BCL, I didn't do corporate insolvency, and I applied to a set that got an awful lot of insolvency work. And one of the first questions they asked me was, why did you apply here if you weren't doing corporate insolvency? Now, that was a pretty robust start, and the interview didn't go brilliantly. But it was a fair enough question. So I think you need to be aware of things like that when you're framing your application. So I mean, I would say to any applicant who is applying, you need to be aware of what your narrative is. Look at the mini-pupillages you've done. What story can that tell? Look at your options or your electives or your BCL or whatever. What story does that tell? And we don't, as Jenny was saying, we don't expect people to come in as perfectly formed pension lawyers, and we'd probably be a bit suspicious if you presented yourself as a perfectly formed pensions lawyer. Whereas if you had a narrative that was, well, I quite like trusts and land and contract, I see you do a broad range, I want to have the opportunity to work out which of those I want to do, that, to my mind anyway, is a sort of a much more compelling answer. So that's what I'd say. I mean, there was a comment in the chat as well about, do you recommend specialising early on, i.e. doing the BVC or pre-pupillage? I think we've probably sort of covered that in terms of what we said. It's about, you could only do so much. And when you do your specialisation or you make your selections, just be aware of what you're choosing. It ought to reflect what you're interested in, because not least, as Jaiwei says, you probably get found out at interview, to be honest.
Yeah, agreed. The related question we've already partially answered is the last question in the chat.
Yeah.
Or the Q&A. As a mature student, can work experience and distinctions in the GDL/BPC make up for a 2-1 undergraduate from a low-ranking university taken early in life? The answer is yes. Again, it's all circumstantial, but one is looking at evidence of intellectual ability. So if you've got a 2-1 degree from 15 years ago or something along those lines, and recently you've done the GDL or the BPC and gotten a really top grade in it, we're more likely to look at your recent qualifications and say, okay, well, what happened 10 years ago has less of a bearing on how we assess you now, for example. Obviously, especially if the degree done 10 years ago is in chemistry, whereas you're doing that one in law now, for example. So the answer to that is yes. And how far you get with those qualifications will depend, among other things, on who your competition is that year. If the pool is slightly weaker, then you're more likely to get in for an interview. If the pool is stronger, then maybe not. But as much evidence as you can muster is furthest we can go.
I think, yeah, exactly. We'd look at what you were doing now and how valuable that was.
Exactly. And it's not just your grades that matter as well, although that's a very big part of how we assess it. Work experience in relevant fields, that matters. If you've done some professional work as, say, a consultant or an accountant, something like that, or people who transfer laterally, actually, from being solicitors to barristers, that experience does count towards whether you have the required intellectual aptitude to cope with this job. So grades are not the only way one evidences ability.
I was going to say that probably links the question above it, which is, for those who've completed the bar course working full time, how would you recommend obtaining further advocacy experience, because a lot of mooting or debating is for students only? I suppose, one, I would check the INs to make sure that their competitions or whatever are only open for students rather than just for anybody who's still looking for pupillage. And the other is, I suspect if you've got a full-time job, you'd be doing quite a lot of work that you can think of as oral advocacy. If you are preparing papers and then speaking in meetings, or if you're managing a team, or you're dealing with customers or dealing with clients, all of those, if you start looking at them through a barrister's lens, become part of oral advocacy. So it's not just about doing the set piece things, it's about identifying what in your day job works and can be explained as examples of oral advocacy.
Yeah. I can see there are also other sort of procedural questions, if you will, about when to apply for pupillage and that sort of thing. If I can take them all at once, and I think that actually covers all the other points that I wanted to make, apart from pupillage award, which is 75,000, you can draw down 30,000 in your BPTC. Just put that information out there. You can find all the details on the website itself. Starting with the top question on the Q&A, I'll answer live. Do you consider international students' application for mini-pupillage in your firm for 2022 in your 4th session? I think 4th session is the one in June, sort of 7th to 8th, I believe. And the answer is yes. It's not considered, I don't think, work, although this is not immigration advice or anything. So long as you've got a right to basically be in the country for that period, I would imagine that it's not a problem if you're an international student. I know there have been a couple who've done mini-pupillages in June, so it shouldn't be an issue at all for us to take you on. If you can identify if you've got any particular concerns about your visa and that sort of thing, flag them in your application so that we know and we can check the position for you. But I can't imagine that there should be any serious problem. And then there's a question about whether we prefer candidates to apply during the year preceding the bar course or during the bar course itself. There's no real difference from our perspective, really. Just bear in mind that pupillage is not normally offered with a year's gap. So if you secure pupillage in next year's round, for example, so you get pupillage in, I don't know, March 2023, then you're likely to start pupillage only in September 2024. And the idea there is to cater for people who still have to do the 1-year BPTC. Obviously, if you've already finished the BPTC, then you've got a year to do something else in that time, and you're free to do whatever you want, really. But there is a year's gap, essentially, from getting pupillage to actually starting it. But we've got no inherent preference between candidates and when they apply.
I think it's fair to say the standard structure is for you to apply and then use the BPTC, use that year's gap for the BPTC, as you say, isn't it?
Yeah, that's what usually happens. But there have been candidates who don't like it. I think one of our, 3 years ago, Francesca, she got pupillage during her BPTC year and then went on to take a year out to work at, I think, a tech company or something like that. Can a pupillage spot be deferred? The answer is yes, it can sometimes, but that really depends, and it'll depend on the scenario. So we can't commit to an answer about whether it can or cannot be deferred. It'll depend on what your circumstances are at that point. So it's all discretionary. Are pupillages portal or non-portal? By that, I take it to mean, are we on Gateway? And the answer is yes, we are on Gateway. So you would make your application via the pupillage Gateway. When our mini pupillage is running, the dates are all on that link that has just been circulated in the chat box. So you can click on the mini pupillage bar on the side, and then it should give you all the sessions that we are running. Has COVID damaged that immediate face-to-face access contact with the more experienced mentors permanently? I don't want to say permanently. I think people are coming in a bit less often than they used. So it's not really a pupillage related question. People are coming a bit less often. So there's a bit more, ringing somebody on Teams. But it's actually still quite easy to just ring someone on Teams. And the same sort of quasi-open door thing is happening there as well. I think more and more are coming back. Yeah.
When you're doing your pupillage, you'll always have that face-to-face contact. So your supervisor will always be there. And then you'll build up that relationship. So you'll feel more comfortable with speaking to someone remotely, for example, if you're subsequently both working from home.
Yeah. There are still a lot of questions now in the Q&A box, and I think we can group them because we're all at 2 o'clock now. A lot of the questions about when one applies for a mini-pupillage, you can actually apply for a mini-pupillage in your first year at university as well. There's no specific disadvantage for starting before the bar practice course or anything like that. In fact, our mini-pupillages are catered for different year groups. So you can go online and check which year group those sessions apply to, and you can apply and submit an application. If there's any information that's missing, feel free to email the I think it's Nancy Lee, the coordinator for mini pupillages and pupillages generally, and she'll give you an answer about which session is allotted to what category of students.
I was going to talk about. I was going to pick up a question about how easy it is to move chambers and how committed or welcoming chambers is in relation to minority groups. So. Moving chambers, to be honest, it's not that easy. It's a pretty traumatic because you've built up relationships in your existing chambers, and it's often a bit of a process to move. It's a bit like getting pupillage, really. You kind of have to go through an interview and submit pieces of work. So try and pick your chambers at the start with that in mind. And then dealing with the Wilberforce's approach to minority groups. So in relation to gender, we're really championing gender diversity. And I know when you look on the members of chambers, it does seem quite male dominated, but that's changing. And for example, Wilberforce is promoting initiatives such as the Voices of Women at the Chancery Bar to encourage a more diverse and a fairer representative bar. There's also an upcoming Women at the Chancery Bar webinar. And in relation to social mobility, Wilberforce is promoting a number of groups that help champion that aspect and provide support to students there. And more information will be available if you look on our website.
Do we have enough time to answer more questions, or are we? There are a couple of stray ones here and there that we haven't quite gotten to yet.
Yeah, maybe take a couple more.
Yeah, I mean, one or two more. Let's just go through them and just make sure that we have answered.
Are pupils encouraged to work in other practice areas than that they are interested, specialised in? Yes, we structure pupillage. We have, so you basically spend 6 weeks to 2 months with each of your supervisors, and the aim is to ensure you get exposure to all of Chambers practice areas. And if you haven't seen all of Chambers practice areas, they will try and get you to see somebody who does the area that you haven't covered. So that is something the pupillage committee are very alive to and spend quite a lot of time putting their matrices of supervisors together.
Yeah. There's a question here about how pupillage committee tries to diversify pupil intake from other university backgrounds. The answer to that is really that your specific undergrad degree, where it comes from, is not as important as the degree classification, if you will. So a first-class degree from a university is effectively regarded in much the same way. Obviously, if you topped a certain subject at university, that's regarded in the same way, no matter what university that degree or that prize comes from. The complication will be if the degree is not from England and Wales and the grading scales are different, but that's not really a problem about diversifying access. That's really finding a comparable way of deciding whether or not that student's achievement is equivalent. But it's not about the university, it's about the grade banding they utilize. So that's really the primary way that we aim to diversify. So it doesn't matter really what university you're from, it's how well you've done. And
we're doing webinars like this with a view to trying to get exposure out there for people who
exactly.
Maybe don't know the commercial chancery bar, who don't have the as well structured pathways.
Yeah.
So
I think hand on heart we can say our aim is to get the best people in. We're not fussed about where you come from, frankly. So if you're good at law, you're clever, you're willing to work hard, we'll take you. just make sure you apply so that we can take you. That's the key thing. I don't think we've got time for it. Oh, can you reapply for pupillage if you're unsuccessful first time? Yes. Short answer. I think that's important for you to know. So just try. What's the worst that could happen?
So I think there are probably a couple of questions out there, but we've done our best. So thank you all for coming. This webinar, if you want to go back or you want to recommend it to anybody else, it will be up on our YouTube channel later in case you've missed it. If you just type Wilberforce Chambers into YouTube, we will be there. If you would like to hear from more of members of Chambers and discover more, going actually to the diversity point, we have a Women at the Chancery Bar talk coming up on the 21st of June with Marcia Shakadamian QC, who wrote the report that Jennifer referred to, Anna Littler and James McCrath, talking about Chambers' approach to that and tips for pupillage applications. So again, that's on LinkedIn where you can register, and Zoom will be round. There will be a feedback form popping up once the session is over. Please do fill that in. This is the first time we've done something like this. We want to know if it works, what we could do better, what's useful, what isn't, and we can only be as useful as the feedback we get. So please do fill that in. And finally, it will help us, it will help you. Follow us on LinkedIn, Twitter and YouTube, where we get the benefits of your followers and you get the benefit of all our educational legal content. So thank you very much. Thanks for all the questions, because as I said at the start, it really does make a difference for us, because it means we can answer the things that really are on your mind. So thank you very much, everybody. And I hope to see some of you interviewing Chambers in due course.
Thank you.
Thank you. Bye.